You've been charged with aggravated assault. Maybe there was a fight. Maybe a weapon was involved. Maybe you were defending yourself. But right now, none of that matters as much as this. The prosecutor is already building a story about what happened. And if their version of events wins, you're the one living the felony record, possibly prison time and consequences that could follow you for the rest of your life. Here's what most people don't realize. A lot of aggravated assault cases are won or lost long before trial. They're won because a witness changes the story. They're won because self-defense is supported by the evidence. They're won because the state can't prove a critical element. And they're lost because the defendant panicked, started explaining, started texting, started posting online, or made statements that prosecutors later used against him. I'm John Cannon, an Oklahoma criminal defense attorney, and I've defended aggravated assault cases across the state of Oklahoma. In this video, I'm going to show you the same pressure points I look for when evaluating these cases, how aggravated assault cases fall apart, how self-defense actually works in the real world, not on television, and the mistakes that can turn a defensible case into a conviction. Because if you're facing this charge, understanding where the battle is fought may be the difference between protecting your future and handing the state exactly what they need. The first thing you need to understand is what aggravated assault really means in Oklahoma, because this isn't treated like a minor fight. This charge usually shows up when the state claims one of two things. Either the injury was serious enough to be considered great bodily harm, or they claim a dangerous weapon was involved. And once it's labeled aggravated, everything gets heavier. Bond conditions, prosecutorial attitude, potential prison exposure, and the way it follows you even after the case is over. This is also why people make bad moves early. They panic. They assume the label means the case is already over. It doesn't. But you have to treat it like a chess match, not a shouting match. And that starts with what you do next. Get your story straight and don't talk to the cops alone. If you're accused of aggravated assault, your instinct is usually to explain. You want to tell the officer what really happened. You want to clear it up. You want them to understand you weren't the aggressor. But here's the problem. The police report is not a neutral summary of the truth. It's a document built to justify an arrest. And when you talk without counsel, even a normal sentence can get framed as an admission. People don't realize how easy it is for your words to be reshaped. You say, I pushed him off me. It gets written as, he had admitted using force. You say, I grabbed something because I was scared. It gets written as, he armed himself. So the safest rule is simple. If police are questioning you, you say, I want a lawyer. And then you stop talking. Your story matters. It just has to be told at the right time, in the right way, and with the right evidence behind it. Which brings us to the next step, finding the weak spots in what the state is trying to prove. Aggravated assault cases are almost never clean. They're usually chaotic, emotional, fast, and filled with people who are angry, scared, or trying to cover themselves. So when we defend these cases, we're looking for the weak link that breaks their version of events. Here are the big ones. Was the injury really great bodily harm? The state loves strong words. They'll describe an injury in the worst possible way because it can support a felony. But sometimes when you get the medical records, it doesn't match the drama. Swelling, bruising, a cut, those can look bad in a photo, but that doesn't automatically equal great bodily harm. And if the injury doesn't meet the legal threshold, the entire charge level can be challenged. Was there actually a dangerous weapon? Another common upgrade is the weapons claim. Sometimes it's a knife or a gun. Other times it's something random, a bottle, a tool, a chair, anything they can call a weapon. But not every object becomes a dangerous weapon just because it was present. How it was used matters. Whether it actually created a deadly risk matters. And the more exaggerated their weapon claim is, the more room there is to attack it. Are the witnesses reliable? This is the biggest one. Most aggravated assault cases depend on people's stories. And people's stories are often messy. They change, they conflict. They leave out what happened before the moment of impact. They get influenced by friendships, relationships, fear, alcohol, and ego. If the whole case is he said, she said, with shaky witnesses, that's not a strength for the state. That's a vulnerability. And that leads directly into self-defense, because self-defense doesn't live in a slogan. It lives in the details. A lot of people think self-defense is just saying, I was defending myself. But self-defense is a legal argument, and it has to fit the facts. The core question is this: did you reasonably believe you were in immediate danger of being harmed? And then right behind it is this: was your response reasonable based on what you believed in that moment? So here's where self-defense wins cases: when the threat is real, the danger is immediate, and the response matches the situation. And here's where self-defense collapses: when the threat is over, the other person is backing off, and the force keeps going or is far greater than it needs to be. That's why the timeline matters so much. The seconds before the incident matter. The exact moment of escalation matters. And what happens after the threat ended matters. So when someone tells you they started it, my next question is always, okay, what happened right before you used force? Because that's where the case is decided. Now, let's talk about the evidence the state will use to try to lock you in. Prosecutors love videos and photos because they feel convincing. But here's the trap. Videos usually capture the middle of the story, not the beginning. A clip might show you swinging, but it might not show the threat, the shove, the bottle in someone's hand, the crowd surrounding you, or what was said seconds earlier. Photos can be even worse because they freeze the aftermath and remove the context. So the defense approach is always the same. What does the evidence show? And what does it fail to show? Because what's missing is often where your defense lives. If there's security footage, we look for angles and timestamps. If there are phones, videos, we look for what happened before the clip started. If there are injuries, we compare the photos to actual medical records. The state wants the evidence to feel final. Our job is to show the rest of the story. And once the full story is clear, that's when negotiation leverage shows up. Not every aggravated assault case should go to trial. And negotiating doesn't mean surrendering. It means forcing the state to acknowledge their weak points. If the injury isn't as serious as they claimed, that matters. If the witnesses are inconsistent, that matters. If self-defense is credible, that matters. And those facts can lead to real outcomes: reduction to a misdemeanor, dismissal in the right situation, deferred options when available. Probation structures that protect your future more than a felony conviction does. But here's the part people miss. You only get strong negotiation power when you've done the work, when the state knows you can expose the flaws if this goes further. That's why rushing to a just take a deal can be the biggest mistake, which leads to the final step: working the process without letting fear steer the wheel. If you're facing an aggravated assault charge, fear will try to make decisions for you. Fear makes people talk. Fear makes people accept the first offer. Fear makes people think their life is already over. But cases don't get won in one moment. They get won step by step. Here's the typical flow. You have an initial court date where charges are addressed. Then your lawyer gets discovery, reports, statements, videos, medical records. Then you identify the pressure points and challenge the weaknesses in the government's case. Then you decide whether the best outcome is negotiating, motion practice, or trial. And you don't decide any of that until you actually see what the government has. Because the biggest advantage you can have is clarity. Once you have clarity, you stop reacting and you start controlling. You start being strategic. Now, here's the part a lot of people miss. In aggravated assault cases, the damage is not always done in the fight itself. A lot of times it happens afterwards, when police start talking and you think you can explain your way out of it. That is exactly where people get trapped, because officers are trained to use pressure, half-truths, and flat-out lies to get you talking. And once you start talking, they start building the case around your own words. So your next step is my video, 10 Lies Police Love to Use and How to Shut Them Down. In that video, I break down the most common things police say to get people to drop their guard, start explaining, and hand over evidence without realizing it. Go watch that next, because knowing how that game works can keep you from making this case even harder to defend. Go watch that next, because knowing how the game works can keep you from making this case even harder to defend.